here is when a complaint is received in electronic communication. So what happens when electronic communication mode any complaint is received? I am also very curious. Though in the new law, there is a complaint that can be received in the form of electronic communication. Since the implementation of the law till date in the entire country, has the police stations across the Manipur state, have they ever received any complaint in the form of electronic communication? This is one of the curiosity I had yesterday. So when electronic mode complaint is received, information is received through SMS, WhatsApp, email, social media platform, website, etc. And then we have to make an entry in the general diary. I'm sure that every investigating officer must be having already well-equipped knowledge about this, but we would like to reproduce again. When the electronic complaint is received via electronic communication, we have to obtain the signature of the complainant within 3 days. So in this regard also, what if the complaint signature could not be obtained within the 3 days, then whether it will not be taken as an FIR, and what about the appropriate response? Whether once a complainant is filing a complaint to the concerned police officer through the concerned email ID or WhatsApp or whichever electronic mode, and if suppose has any infrastructure setup or any kind of emails or any kind of numbers that are already publicized to the general public for making this particular mode for accepting FIR more acceptable. This was one of the curiosity which I would appreciate to learn later in the reflective session. And then to append the signature within 3 days and issue FIR if the informant complainant attends and puts signature. If fails to appear, need not issue FIR. When a complaint is received, we all know we have to segregate between cognizable and non-cognizable offenses. In case of non-cognizable offenses, we have to take permission from the magistrate, and then after that, we have to proceed with the investigation. But in case of the cognizable offenses, again, this is categorized into several punishable with 0 to 3 years, 3 to 7 years, like that, and accordingly, the investigation will be different. Regarding the preliminary inquiry, as stated before, my sister will be covering it later. Regarding the non-cognizable offenses, first, the complaint should be entered in the general diary, then advise the complainant to approach to the court, send the daily diary report of all such cases fortnightly to the court. This is one of the emphasis I want to request all the officers present here, that regarding the maintenance of the case diary. In the past, we have experienced that because of some difficulties of not able to produce the case diaries, sometimes we are not able to arrive at a discretion when we consider bail applications and so forth. So with the new implementation of the law, I hope that we can coordinate more effectively and the case diaries for every offenses or every FIR registered be maintained, and it can be helpful for the courts in order to make an effective and efficient just decision. After that, where FIR is registered, registration of the FIR is to be on the basis of the place of occurrence or the offense. If the same police station then registers or issue today, just a couple of minutes ago, we had a remand where the copy of the FIR was also not given. This is not because of the lack on the part of the investigating officers. Maybe there might be some issues regarding sometimes in Manipur may lack train a pibangamdaba adagi family do lack train a pibangamdaba, but FIR gi copy say accused ki family da at the time after arrest is made, it is requested the copy. These small gestures and these small compliances make a big difference. So this particular topic has been all mixed up with the zero FIR concept, where zero FIR concept, we all know when any offense is reported, it can be registered anywhere, even though it is not in the same jurisdiction. So where FIR, if in case, what is to be done promptly regarding the zero FIR, we should remember in case of zero FIR, like last year we had a lot of conflict situation where zero FIRs were in prominent all over the police stations, how 0 FIR were registered regarding the conflict. So I think what is important and new about this present new provision of FIRs regarding the 0 FIR, which calls for promptness on the part of any police stations who are registering it to transfer the information to the concerned jurisdiction police officer, police station. So issue 0 FIR and transfer the FIR to the concerned PS immediately. This is immediately is the key word. Arrest accused if he may abscond and seize any material evidence, even though the concerned police officer is not from that particular jurisdiction. Accused and the material evidence seized, if any, to the concerned police station immediately. Send, furnish a copy of the FIR to the complainant or the victim. This also. Sometimes these are things we generally read again and again in the provisions, but these are the same provisions that we fail to comply. So regarding the furnishing of the copy of the FIR, regarding the furnishing to the victim also, to the accused also, maximum of the cases where remand productions are produced before me, so far my humble experience is concerned, this has not been complied with. So it is requested that without any default or any lack on the part of the investigating officers, these small compliances will do a long way in the future. Okay. So, I will not read out word to word in the provision of 173 of BNSS, but as I share the provisions, I would also like to place what are the challenges that we face as magistrates while we go along with the processes. So, the new provision, sorry, before I go with the 164 challenges that we face and 161 former provisions, in the new FIR 173 information in cognizable cases, there's an additional provision in proviso to subclause 2, subclause 1, which talks about certain offenses, especially those offenses under the sexual offenses against the women and asset attack and sexual harassment and criminal force. These are certain categories where any victim who are of these offenses are the complainant or they are the victims. Their recording of the statement is to be done at the place of their convenience or at their residence. Then the recording of the statements of these statements should be videographed. Then again, regarding the one challenge that we faced recently regarding one case was where there was a case on attempt to rape very recently, and the FIR was registered very belatedly. However, because of the lack due to the gap of the time, even the victim was not taken or produced for the medical examination before the medical officers, and therefore on the production of the first remand without the medical examination, the IO was not equipped as to even whether the attempt for rape cases has to be medically examined or not. So under the new provision of 184 and I think section 57. The victim as well as the accused persons, even though they are not for the attempt of, not for the case of commission of rape, but even for the victims of the attempted rape, even they are to be medically examined by the medical practitioner. This is one of the things that I would like to highlight. I'm quite... regarding the new remand provision, as we all know, there's the maximum period of 15 days of police custody, which can be sought for within the first 40 days or the 60 days, where we all have been that change has come under the new BNSS. This is regarding when the FIR, if FIR is not registered and the investigating officer refuses to file an FIR, then this is the same as before. There is no change in this regarding the complaint petition. Information is to, if the complaint petition is not accepted by the investigating officer, then informant is to approach the magistrate and then make an application along with the complaint under section 210 of the BNSS. On receipt of the complaint, magistrate is to firstly verify whether the complaint is supported by an affidavit or not. Even till date, we all know this provision a lot properly, but then even till date, sometimes the complainant approaches the court with a grievance that the SP also has not entertained the investigation and the FIR has been not registered. But when they come, they still, it's a repetition every day. We all know it's already there in the law, but then it's a repetition, but some still come without an affidavit properly regarding having approached the concerned IO or the concerned SP of the concerned jurisdiction. So this is the provision, same as before, no change in this. Guidelines on registration of zero FIR, I'll repeat again. Eligibility to register zero FIR. A zero FIR can be reported by the victim, a family member, a relative, or any other individual with knowledge of the facts relating to the incident on behalf of the victim. Then obligation to register a zero FIR. FIRs are typically filed by the police station. I think I'll just this is something that I would like to draw the attention of the investigating officers. This has been taken from the SOP from the state of Telangana, and I think this will be very handy when dealing with the registration of the zero FIR. Under section 173 subclause 2 of BNSS, it mandates, there's a mandatory provision, it says that if the report is received through the electronic communication, it shall be taken on record by him on being signed within 3 days. I think I've already stated this before. And if the informant did not turn up within 3 days, the information discloses cognizable offense. After ascertaining truthfulness of the incident, alleged in report will be transferred to the jurisdictional police station for action. As a matter of fact, crime is not only against victim, but it is against the society as well. The accused cannot go, okay. I think I'll just, I'm getting a little nervous, so kindly pardon me. I'll come to the point of regarding the recording of 161 statement, former 161. Serial number say. Regarding the 161 recording of 161 CRPC statement, which is now in the 180 BNSS, investigating officer is empowered to summon any person in writing except male under the age of 15 years or above the age of 60 years, or mentally or physically disabled person or acute illness person or women who is acquainted with the facts of the case of his jurisdiction or neighboring station for examination and record the statement, and such person shall attend. So this, I think this is a new provision that has been incorporated under section 180, which is former 161 CRPC. Okay. I think I'll come to former 164, which is 183. When recording the 164 statement by the magistrate, some issues or some challenges were faced, I think even with the new law also, the same might be experienced. So regarding when recording the 164 statements previously, which is 183 now, I think there was instances where we were faced to record the statements of the specially abled persons, and that time previously, since with the coming of the new law, I'm sure that we will do away with a lot of challenges. But during that time, when specially abled category of victims are brought before the court, so there was an issue regarding how the procedure will be taken regarding the videography. So for that also, with the coming of the new law, I think this challenge will be can be done away as to how the video, the entire proceeding for facility to be provided by the investigating officer for videographing the recording of the statement of the specially able category. These were some challenges we faced previously. So I think that later when we are discussing in the discussion session, maybe we can elaborate on that aspect also. I'm just jumping from one topic to another topic, but some of the important things that I thought would be practically more helpful that I've taken up. And we have a new provision under section 193 of the BNSS, subclause 3, subclause 2, which mandates the progress of the investigation to be communicated to the victim within 90 days. So this is a very small provision, but I think this will do a lot of assistance in expediting the processes, because what we face in our courtrooms is that we keep on calling for the status report all the time, again and again. So I think this particular provision of 193 subclause 3 subclause 2 for informing the status of the investigation to the victim, I think within 90 days, and this is a very this is going to be a very helpful provision under the new law. And then regarding the test identification period also, there is no much change under section 54. Before, I think previously it was regarding videograph, but now the new law states regarding the videograph recording of the TIP period, which can be done even by the mobile phones also. Then when the investigation is over, there's a new provision which corresponds to former section of 207 of CRPC. Now it is 230, where the RP, the relevant papers, has to be mandatorily supplied to the accused person within 40 days from the first date of production or appearance. So these are certain relevant provisions which I, as a magistrate dealing in the forefront, I think these are certain small provisions here and there which, if complied properly and if coordinated all together, I think this will really help in the smooth and efficient investigation at the pre-trial stage. Kindly, I must have made some mistake or must have left a lot of things which will be deliberated maybe later in the question and answer session. I think with this I'll take my leave. I'll end here.
So, shall we proceed with the reflective session for this session, third session, or shall we proceed with the fourth session and do the interaction together? Together, okay. Then I would request Neera Sinam to give on the topic arrest, seizure, and preliminary inquiry under BNSS. And we'll do the interactive session together, since some of the topics are overlapping with the third session. Thank you.
A very good evening. A very good evening to everyone gathered here today. Sir Elek Moiva Sir, Member Secretary, Manipur State Legal Service Authority, my senior judicial officers who are very much respected, my fellow judicial officers, police officers, and also officers from the central forces, learned prosecutors, learned legal aid defense counsels, and also forensic experts who are present here today. My name is Neera Sinam. I am currently posted as a Judicial Magistrate, First Class Kakching, and I have chosen these 3 topics which are here today because I'm also currently Duty Magistrate for both Thoubal and Kakching, and these 3 topics I believe I have been in touch with. So basically that's the reason why I've chosen this topic. As in the morning inaugural session, Sir Elek Moiva had told us that there was a commando unit who had told Sir that they also wanted to be here because of the seizure topic. So for that very reason, I think I align with the thoughts of that commando unit also, because I'll be spending 30 minutes on the seizure topic, I'll be spending 5 minutes on preliminary inquiry, and I'll be spending 10 minutes on arrest. So the topics which I'll be dealing under the topic arrest are changes in the provision, memo, the case laws and looming questions that police officers might have. Okay, so the first change is under section 35 BNSS. The marginal note is when police may arrest without warrant. There are 2 additions as we can see here. The first one is section 41 CRPC is already there as part of section 35 BNSS. This was the first corresponding provision. The first addition, in addition to that, would be section 41A CRPC. Section 41A CRPC deals with notice for appearance of the accused person when he's not arrested. The second addition is section 35, subsection 7 of BNSS. What does it state? No arrest shall be made without prior permission of the officer not below the rank of the Deputy Superintendent of Police in case of an offense which is punishable for imprisonment of less than 3 years and such person is infirm or is above 60 years of age. So the prior permission of the Deputy Superintendent of Police is required when there are 2 conditions. First of all, we have to see that the offense is punishable for imprisonment of less than 3 years. The second condition is the person has to be above 60 years of age or he has to be infirmed. This is a pro forma and requisition for arrest from the Deputy Superintendent of Police for this particular section that I had taken out from the BPRND website. So this is a pro forma which has to be submitted to the Deputy Superintendent of Police where permission is being sought so as to arrest the particular conditions, the accused persons who fall into that particular scenarios. And this is a pro forma that has to be given by the Deputy Superintendent of Police to the investigating officer concerned under section 35, subsection 7. The second change, section 37 BNSS, marginal note, designated police officer / control room at districts. The second part of the marginal note relates to section 41C CRPC. The first part of the marginal note relates to section 37 BNSS. So with the first modification under the subtable of section 37 BNSS, we can clearly see that I have written that there is no change in content. Section 37(1)A basically corresponds to section 41C(1)A and section 41C(1)B. Now the second modification, however, there is certain change. Before under section 41C CRPC, it was stated that the state government shall cause to be displayed on a notice board kept outside the control room of every district, names and addresses of the persons who are arrested, and the names and designations of the police officers who have caused such arrests. But under section 37B, it becomes very specific. There should be a designated police officer in every district and every police station. The rank should not be below the rank of sub-inspector of police, who shall be responsible for maintaining the same database. And where should it be displayed? It shall be displayed prominently in every police station and district headquarters. The removed provision being it will no longer be displayed at the police headquarters as such. There's one more modification. It shall also be displayed in digital mode. This is a pro forma of information of arrest to be given to the designated police officer at the district level. So basically every IO concerned, every or the OC should submit to the designated police officer of their district, of their police station, as to the information of the arrested person, as to who is their designation itself also. As you can see, I won't go in much into the details. And it shall be signed by the signature. There shall be a signature of the investigating officer or the station house officer. Okay. Next change. This is the second amendment. Arrests by private persons and procedures on such arrests. New section, section 40 BNSS. Previous section, section 43 CRPC. So we can see a highlighted part in this edition that I've written. It says, but within 6 hours from such arrest. So the private person, after he has arrested a person who commits a non-bailable and cognizable offense, he may be allowed to arrest a proclaimed offender. He should hand over this arrested person to a police officer, but within 6 hours. And this is made clear by the next model pro forma, which I had taken once again from the BPRND website. Acknowledgement of arrest under section 40, subsection 2, BNSS, memo of custody. This is to inform you that this and this accused person has been arrested for committing such offense and so on and so forth, and that the investigation is being carried out. One thing I would like to point out is the fact that they share the same pro forma. In the previous pro formas that I had shown everyone, the police officer seeks permission from the DSP. The DSP then grants the permission. In this case, they share the same memo. As we can see, there's the signature of the arrestee, the signature of the private person who's making the arrest, and then there's the signature of the police officer / the investigative officer. The fourth change, arrest how made. Section 43 BNSS, this is a completely new change, the addition, although I have written that there is a comparative marginal previous section, which is section 46 CRPC. The police officer may, keeping in view the nature and gravity of the offense, I have not highlighted this, but the main change is the fact that police officers are now allowed to use handcuffs. This was not actually allowed as per previous judgments of the Supreme Court unless there is a permission which is granted by the magistrate, unless there is a heinous offense involved which necessitates the police officers to use the handcuffs. A list of offenses are given here, as in addition to the list of offenses, we also have the police officers may use handcuffs while producing such person, considering the nature and gravity of the offense. Before the court, he should be a habitual or repeat offender, or is a person who has escaped from custody. And then we go into certain heinous offenses which are listed out here. Fifth change. Marginal note, examination of accused by medical practitioner at the request of the police officer. Section 51 BNSS. So the addition that we can see here is that the registered medical practitioner, without any delay, forward the examination report to the investigating officer. There is a statutory mandatory implementation, mandatory provision now that the registered medical practitioner, which was not present in its corresponding previous provision, section 53 CRPC, that they should forward immediately to the investigating officer the examination report. Now the final change. Examination of accused persons by medical officer, section 53 BNSS. The addition being first proviso to section 53 subsection 1. Now this is a discretion given to the medical officer. If the medical officer by any chance feels that one more examination of the person is necessary, it is at his full discretion to do so now. So police officers, investigating officers, I hope that they take note of this. If the medical officer deems fit that he conducts the medical examination again, he now has the discretion to do so. Okay, this is the, this is the new arrest memo. I have not written down the particulars. I just extracted it from the arrest memos which are being submitted to me. Why I've laid down this, it doesn't have a lot of change from the old arrest memo except for a little bit of tabulation and everything. I want to draw attention to point number 8. Name, address, email, telephone number, whomever the arrest information is being conveyed. I thought that since this change has come, a lot of police officers would actually implement this, but I would say most have actually implemented it, but some are still writing that they have conveyed the information to their family member. They have not written the name, they have not written the email. So, as you can see on the top, it writes, this arrest memo is being prepared as per direction of the Honorable Supreme Court of India. Why I'm bringing this up is because this particular is very much related to this direction that is being talked about, which I'll be discussing later on. Here it is. DK Basu versus State of West Bengal. There is a clear guideline where it's written that at least the name of the next friend which is being informed about the arrest, he should be given information of the arrest. So, unfortunately, as I mentioned, in certain very minute number of cases, it's still written to the family member. So the looming question arises. What is the consequence of a violation of the guidelines under the DK Basu versus State of West Bengal? It states, failure to comply with the requirements herein above mentioned shall, apart from rendering the concerned official liable for departmental action, also renders him liable to be punished for contempt of court, and the proceedings of the contempt of court will be instituted in the High Court. For our state, the High Court of Manipur. So there are two consequences the police officer will actually face. Now, this is a pro forma which I wish all the investigating officers here will start implementing. Is the arrest intimation to the family member. Actually, in addition to the arrest memo, this form also has to be given to the family member concerned, to the next friend who has been informed. Secondly, this has to be submitted to the magistrate as proof that they have actually been informed, because you can see there's a signature of the relative. So the magistrate concerned, the duty magistrate, they can be convinced that yes, they have been informed. Okay. Now, although this is not related to the new change, I have just added this case law. Consequence of the violation of provision of checklist. I think all the investigating officers are aware of this case law by now. It's Arnesh Kumar versus State of Bihar. So there's a lot of question. What if I arrest a person on the spot? Right? I think there was one person who was asking that question also. What if I arrest a person on the spot? I don't bring a checklist. In that regard, magistrates, us as conventions, we don't really require a checklist at that point because you have already skipped that step where you have to give the notice. You have already arrested the person. And you can actually, there is no written rule that a written checklist has to be given. The police officer, if they arrested on the spot because the accused person is fleeing, you can already say that this investigation cannot go on without securing his presence by keeping him in police custody, right? So this can be a submission that can be made to us. However, in other cases, what is the looming question for violation of provision of checklist? The same case law states, failure to comply with the directions aforesaid, again, departmental action, contempt proceedings will proceed. And there's a third consequence that will be faced now, Satyendra Kumar Antil versus CBI. The last line, any non-compliance would entitle the accused to a grant of bail. So unless it's an exceptional circumstance for why checklist is not being produced for cognizable offenses below 7 years, the accused actually becomes entitled to a grant of bail now. Okay, so the change that I had mentioned on the handcuffing of an accused/arrested person, Citizens for Democracy versus State of Assam, AIR 1996, this is the best case law to refer to because it mentions this. Where a person is arrested by the police without warrant, the police officer concerned may, if he is satisfied, on the basis of the guidelines given by us in para above, that it is necessary to handcuff such a person, he may do so till the time he is taken to the police station and thereafter his production before the magistrate. Further use of fetters thereafter can only be by the orders of the magistrate. This is not an overruled judgment. So it means that even if the police officers are producing this accused of heinous offenses, this accused who are habitual offenders in handcuffs, they can do so only until they get the orders of the magistrate. They have produced him before the magistrate, now they have to get orders to handcuff him further. Now what is the consequence of violation for this particular case law? The directions which are given in this case law. contempt of court. It's all similar, the consequences are usually all similar for violation of these directions by the Supreme Court of India. Okay, now we'll move to the second topic, it's preliminary inquiry. I want to keep seizure as the last topic. It's 3:41 now. I'll try to finish this within 3:46. Preliminary inquiry. The provision, I think one of my senior judicial officers had already mentioned, section 173, subsection 3, is the provision which is associated with this. I'll also be discussing about the case law from where this provision originated, and also some key points that has to be taken away from the SOP that has been uploaded by the BPRND. Section 173, subsection subsection 3. Marginal note, information in cognizable cases. So first of all, the police officers, they received information where there's a commission of a cognizable offense. Not only is it a cognizable offense, it's an offense which is punishable for at least 3 years or more, and it's less than 7 years. Now I've highlighted this part, may. So the word may becomes very important here. One of my learned senior judicial officers, Ma'am Lanlaima, she answered one officer who had put this question that it's actually discretionary right now, because this is the interpretation of a lot of judicial officers that since the word may is used, may with the prior permission from an officer not below the rank of Deputy Superintendent of Police, considering the nature and gravity of the offense, there can be 2 consequences. Proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding with the matter within a period of 14 days. There's a common misconception that the permission that the DSP has to grant, it directly relates to a direction that you have to conduct a preliminary inquiry. It actually says or, so which means that even if the police officer asks for permission from the DSP can grant permission to proceed with the investigation if the DSP himself is convinced that there is a prima facie case. And as I mentioned before, since there is the word, since there is a word may, if the police officer, the one who had asked the question, if there is an on-the-spot arrest which is being made, he himself is already convinced that there is a prima facie case. For now, until further directions of the Supreme Court, this is the convention that the magistrates are following, that he may still arrest. Okay, this is the case law that I was talking about. Lalita Kumari versus Government of UP AIR 2014, Supreme Court 187. So actually, even if this is the case law from where the provision originated, the case law and the provision itself, they contradict each other. Because the case law itself states, if the information discloses commission of a cognizable offense and no preliminary inquiry is permissible in such situation. So as long as a cognizable offense is disclosed, the FIR actually has to be mandatorily registered according to this section, case law. And the point number 3. Now, a preliminary inquiry will be conducted in case the information received, it's an allegation that a cognizable offense is being disclosed, the investigating officer or the police officer concerned is not satisfied with the fact that there is a cognizable offense. A preliminary inquiry will be conducted in that case. But if that inquiry then again discloses the commission of a cognizable offense, then the FIR must be registered. Point number 4. When we talk about preliminary inquiry, it does not mean that the police officer has to conduct a roving inquiry. It does not mean that he has to look at evidence and all, because point number 4 makes it very clear. The scope of preliminary inquiry is not to verify the veracity. Veracity means truth. Veracity have the achumba, or otherwise of the information which is being received. He just has to ascertain, maybe he can start examining, not under 161 CRPC or the correlated provision under the new BNSS, but only to ascertain whether there is any information which reveals that there is a cognizable offense. And as I had mentioned, the case law and the provision actually contradicts each other, because the case law has a very limited set of cases where preliminary inquiry is required, But now we have expanded it. Cognizable offense punishable with 3 years or more, but less than 7 years, is where the investigating officers will have to seek the permission of the DSP. Okay, this is the last subpart of the topic of preliminary inquiry. Key points from SOP. Number 1, a register of preliminary inquiries in the format prescribed by the Director General of Police has to be maintained by the OC, actually. Question to the police officers here, has the DGP prescribed any format? Because I don't have one to my knowledge. Open question to all. Is anyone aware? No? Okay. Second, then there's another format which was to be prescribed. Again, the second one also, a format was also to be prescribed. It says, record the gist of the information. This is for the police officer. Record the gist of the information in the general diary that you maintain and the details in the preliminary inquiry register. Again, this pro forma has to be prescribed by the DGP. I think this pro forma has also not been prescribed yet, to my knowledge. Point number 3. If the preliminary inquiry is not completed within 14 days, immediately proceed with the FIR registration. Point number 4 is even more interesting. Grant permission in writing within 24 hours, this is to the DSP, of receiving the request from the OC. If permission is denied or not granted, or decision is not duly communicated by the approving authority within the time frame, this time frame is 24 hours by the way, the OC will then proceed immediately with the registration of the FIR. Point number 5. If the preliminary inquiry is not completed within 14 days, the inquiry officer will be show cause. If his reply is not satisfactory, what happens? He faces departmental action. Okay, so we are done with preliminary inquiry. It's 3:49. I think I've taken a bit more than 5 minutes. Okay, we are going to the topic that I think a lot of investigating officers have a lot of questions about. There will be 3 questions which I'll be putting to all the investigating officers in the end. So if you have paid attention to these slides, you'll be able to answer those questions. So the subtopics which I'll be dealing with are, number 1, the provisions, yes. Number 2, the standard of procedure. Number 3, the memos and forms. And number 4, the illustrations, which I just mentioned. Okay, as we all know, the general provisions for search and seizure can be found under Chapter 7 of the Bharatiya Nagrik Suraksha Sanhita. Sections run from 94 to 110. The section that we are most concerned about is section 105 of the BNSS, but I'll be dealing with certain key sections before we jump right into that section. So the first section that we should deal with, section 103 of BNSS, marginal note, persons in charge of closed place to allow search. Now, even if this is the marginal note, I would like to make it very clear to all the police officers here, it is just a marginal note. It's a very general provision because it applies to all search and seizures which are being made under chapter number 7, because section 103 subsection 4 makes it very clear before making a search under this chapter. Point number 2 that we have to take away, you have to call upon 2 or more independent and respectable inhabitants of the locality. If there is no person from that locality, the police officer may call from another locality, and the police officer has a full power to issue an order in writing to call such person. A lot of questions might arise from police officers as to whether police witnesses, they are not independent witnesses, but can they be valid witnesses? That I'll be dealing later on in this slide. Some other key takeaways. So the search which is being made, it's made in the presence of 2 independent witnesses. Second point to take away, it should be made in their presence. Third point to take away, a list of all things seized should be in the seizure memo. And in addition to the things seized, we should also list down the places from where all of those seized things are found. So the place, the investigating officer, he may conduct her search and seizure, and it might be found at different localities which are nearby. Even though it falls within his jurisdiction, he has to list down that also. And finally, it has to be signed by all of the witnesses. Okay, this is the case law that I'll be, 3 case laws I'll be dealing with. The question here is, are police witnesses valid as seizure witnesses? Sanjay alias Kaka versus State NCT of Delhi, a decision which was delivered by Honorable Supreme Court of India in 2001, states that we find no substance in the submission of the learned defense counsel that as no independent witnesses were associated with recoveries, doubt is created in the prosecution version. So this case law starts making it very clear. This case law is related with a section 27 recovery. It starts making it very clear that even though the word shall is used for this subsection, it's not really mandatory that there should be an independent witness. Okay, the next case law goes into depth. Kashmiri Lal versus State of Haryana 2013, a 2013 case judgment which was delivered by Honorable Supreme Court of India. So it states that, the second part states, there is no absolute command of law that the police officers cannot be cited as witnesses, which means that police officers can be cited as seizure witnesses and their testimony should not always be treated with submission. The Supreme Court takes into note that in ground reality, the public at large ordinarily shows their disinclination to come forward to become witnesses. But then the Supreme Court also makes it clear, if in the course of scrutinizing the evidence, which means the evidence of the police witnesses who comes as seizure witnesses, if the court finds the evidence of the police officer as unreliable and untrustworthy, the court has the discretion that he be disbelieved. This case law also goes into this particular question more into detail. Sumit Tomar versus State of Punjab. A little bit of the facts I have laid down here because I believe this is also a common fact that happens here in Manipur. So this is a prosecution story. On 27 June 2004 at about 5 p.m. a special barricading was set up by the police party at Basantpur bus stand, Patiala. At that time, the police party signaled to stop a silver color Indica bearing number this and this, which was coming from the side of Rajpura. The driver of the said car, accompanied with one Vikas Kumar who was sitting next to him, instead of stopping this car, tried to run away. But the police party immediately blocked the way and managed to stop the car. Now this barricading and all this whole stopping and arresting, this was happening in an area where there were no inhabitants. So automatically who becomes the seizure witnesses? It becomes the police. Now the Supreme Court holds, in view of the above discussion, we hold that though it is desirable to examine independent witnesses, however, in the absence of any such witness, if the statements of the police are reliable, and when, number two, the Supreme Court goes into it deeper, it should be established that there is no animosity established by the police officer against the accused, then the police officers become valid seizure witnesses. Second section, Section 106 of BNSS, the power of the police officer to seize certain properties. Two types of properties are being discussed here. The first is stolen property. The second the second type of property is property found under circumstances which create suspicion of the commission of any offense. Now with regard, I've highlighted this word found because it raises a question. Sometimes seizures are not made from the spot, to my experience. They're sometimes made at the police station because the police officers would submit that there's a mob, they can't make a proper seizure there, therefore they have to carry it all the way back to the police station and make the seizure. So the question arises, is that a valid seizure? That I'll be discussing again later on. So after we have made it clear, these are the two types of properties where seizure can be made. The second part of the section that we have to take note of is, forthwith we have to, the police officer who has made the seizure, he has to report it to the officer in charge of the police station. Then he has to report it to the magistrate who has the jurisdiction. And then I'll just jump, there's limitation of time, so I'll just jump straight right into the case law. So the question that I had raised, what if seizure is not made from the spot? What if seizure is actually made at the police station? Major Singh versus State of Rajasthan SB Criminal Miscellaneous Application. This bail order by the Honorable Rajasthan High Court, it's a very recent order that was passed. Now this order goes against that question because it replies with a resounding no, because it replies that the credibility of the seizure memo loses significance if the thing is recovered at a distant place and it is taken by the police from the crime scene to the police station and then memos get prepared in the police station. But the surprising part is that this bail order then again relies on an order passed by the Supreme Court, which is Kamlesh Kumar versus Union of India, which provides some sort of exception to this. Because it's highlighted here, it is not comprehensible as to what was the need to conduct the seizure at a place located 20 to 25 kilometers away from the place where the vehicle was intercepted, which is the spot, that too at the premises at the Office of Superintendent CBN Nimaj, and no reasonable explanation has been furnished for the same. So the Supreme Court, in this order, it can be clearly seen that an exception is being provided here. If the police officer provides a reasonable explanation why this search and seizure, the seizure was not made at the spot itself, why it was made at the police station, then it can be a valid seizure. This is made even clearer by a Supreme Court judgment. Those were all bail orders. Kakching versus Union of India, it's a 2002 judgment. The seizure, the same. The seizure was done only at the office of the Customs Department with the accused. While the accused persons were very much present throughout, there was no allegation or suggestion that the contraband article was in any way meddled with by the officers. Therefore, we are of the view that the appellant has rightly been found to be in possession of the opium. We find no reason to interfere with the conviction. So even if the seizure was not made from the spot, if there is a reasonable explanation, if the police officers have not meddled with the thing which has been seized, and also if the accused person is being present, sometimes accused persons are not present at the site of seizure also, then it stands to be a valid seizure. Okay, we're still not arrived at section 185. Okay, last key provision before section 105. Section 185, search by a police officer. Section 185, subsection 1, certain key points which may be taken is the officer in charge, the police officer who's making the investigation. He can search for anything necessary for the purposes of an investigation which may be found within his jurisdiction. The police officer may also make a request that the search for anything necessary for the investigation may be made in an area which is beyond his jurisdiction. Or if he feels like the delay will cause some injustice to the investigation, he himself can go to the other jurisdiction. But this last this last line, it has been made very clear by the previous judicial officers that a lot of times we don't see the diaries, the case diary and all. But if the seizure, the seizure which is being made with no permission, no warrant being asked from the magistrate, you have to record in writing, the investigating officer has to record in writing in the case diary what is the reason you have not sought for any permission from the magistrate for making this search. Again, the BNSS, which has now become very pro-electronic, means it has incorporated the search can be recorded through audio-video electronic means. Section 185 subsection 3 states that it may not be the investigating officer, an officer who is subordinate to him can also make the search. I want to draw attention to section 185 subsection 5. So this search and seizure which is made without the orders of the magistrate, it has to be forwarded forthwith. This is not there under section 106 BNSS, which I talked about before, but it has to be forwarded forthwith within a span of 48 hours to the magistrate having the power to take cognizance of the offense. Okay, now we have arrived at the much awaited section. Section 105 of BNSS. It's a marginal note, recording of search and seizure through audio, video, electronic means. First point, process of conducting search and taking possession of any property, this is to be recorded. The search may be made under chapter number 7, the search may be made under section 185. The audio video recording should also contain, in addition to the process of conducting search being recorded, preparation of list of all things seized. So we have process of conducting search. Number 2, preparation of list of all things seized. Then there has to be signing of the list by the witnesses. And again, it should be recorded. As I stated, there is an audio video recording. It should be done preferably through a mobile phone. And then without delay, it has to be forwarded to either of these 3 authorities, the district magistrate, the subdivisional magistrate, or the judicial magistrate first class. Okay. For this seizure, for this subsection, a very related subsection from another act comes out from Bharatiya Sakshya Adhiniyam 2023, and that is section 63, and in particular section 63 subsection 4 subsection C. I think every investigating officer must be aware of this certificate at this point. If the investigating officers must have seen, there are two parts here. Part A, Part B. Part A to be filled by party, Part B to be filled by the expert. So the question arises, who exactly is the expert to Part B of certificate under section 63, subsection 4, subsection C. So as per section 63, subsection 4 of the Bharatiya Sakshya Adhiniyam, it states, an expert shall be evidence of any matter stated in the certificate, and for the purposes of this subsection, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it in the certificate specified in the schedule. In the SOP which was uploaded by the BPRND, they make it very clear that there will be 3 types of experts. Just go to the last slide. Okay, first it begins. It's not the person recording, it's the OC. The OC of the police station, he has to fulfill one condition. The OC who was evidence to the chain of events which was taking place is best to ascertain the authority on his knowledge and belief. If there is a first responder, the person who records the video is known as a first responder here. If the first responder records the video, there's a forensic team in charge who may be there with them. They can also be the expert which can fill Part B of certificate. The second para, the first responder or the OC can submit the record of audio-video documentation in mirror copy along with chain of custody of primary evidence. So this chain of custody and mirror copy which I have highlighted will be discussed later on. This chain of custody, it starts with the first responder who has recorded the video. He has to sign it, the expert has to sign it. I'll be discussing that later on. The third person, by the way, which also can be the expert in this case could also be, this last line, responsible officer of sufficient seniority. That can be the OC, it can be a non-OC officer also. He is himself evidence of the whole process. There is an or here. If he is not himself evidence to the whole process, at least he should be such an officer that he can state to the best of his knowledge and belief that the affirmation of the handler as to the continuity, that he continually recorded all of these procedures and that it is authentic. So in conclusion, there are 3 persons that the SOP has laid out very clearly. The OC, who is evidence to the chain of events, the forensic team in charge, which has accompanied the police officers, and number 3, responsible officer of sufficient seniority who can state to the best of his knowledge and believe that affirmation of the handler, that it was continuous, that the audio-video recording is authentic. Number 2, as I had mentioned, I would like to discuss about this subtopics, mirror copy, chain of custody, and hashing. Mirror copy and hashing. The evidence specialist or the designated officer will copy without opening, please pay attention to the word without opening, the digital images / video onto a hard disk or pen drive or storage devices, which will become the master negative. I want every investigating officer to pay close attention to the word master negative, because this master negative is not the one which will be submitted before the court. It states here, the master negative or pen drive or storage device shall serve as a permanent record because it cannot be altered once written. This master negative disk or pen drive or storage devices should be placed in a secured location or a designated desktop, and it is never a part of the investigative case files. So what is exactly submitted to the court then? The mirror copy. The second para states, the files on the master negative pen drive or storage devices should be copied, again, to be noted, without opening onto another pen drive or storage devices. This second pen drive is the one which actually becomes the working record. This is the record that has to be submitted before the court. It is also known as a mirror image. The other alias name is a negative duplicate. Okay. So the hashing, the hash value generation through all of those algorithms which are written in the certificates which are being submitted before us magistrate. When is the hashing actually done? The hashing is done at this stage where from the master negative pen drive it's transferred to the mirror copy. It's done at this stage, it's written here, while transferring data from the mobile audio video recorder to the dedicated computer hard disk or storage device using various tools and softwares. I believe there are police stations, I might be wrong, they use the app Access Data FTK Imager. Do certain police stations use that for transferring? I'm asking the audience of police officers because I've come across this. Yeah, thank you, sir. Yeah, so they use this app, right, to transfer. Now this transfer, please pay very close attention to this line. Transfer should be depicted in chain of custody forms with responder and evidence expert signing duly. So there is a chain of custody form. There's a misconception, I believe, that only the certificate under section 63, subsection 4, subsection C is to be submitted to the court, but no, the chain of custody is very, very important. And the chain of custody is to be signed by the first responder, right, the person who's recording, and then the evidence expert also. It's not even only the investigating officer who has to sign it. And this chain of custody becomes very important later on when the charge sheet is submitted, because to my knowledge, chain of custody has to be submitted along with the charge sheet also under the new BNSS. I've been talking about the term hashing repeatedly, but what exactly is hashing? Hashing is the fingerprinting of any digital data present in non-volatile medium, and it may be done in respect of any file, folder, or complete media which contains data. Hashing is mathematical algorithm applied on a particular data to generate an alphanumeric string of characters of fixed length. I'll just stop here, and I want everyone to focus on these words. Alphanumeric string of characters of fixed length. So the hash value, it's called the hash value. A lot of investigating officers, I believe at this point, are aware of what this combination, this string of alphanumeric characters look like. So that process to generate that hash value, it's called hashing. So hashing is done of both of the primary evidence. There are two primary evidence which will be here, which is the courtesy of explanation 6 to the Bharatiya Sakshi Adhiniyam. Hashing is done of primary evidence, that is the original media, the master negative, as well as of the mirrored copy of that master negative, to prove that both have the same hash value. So explanation 6 of section 57 BSA, as I said, supports this because it states where a video recording is simultaneously stored in electronic form, transmitted, broadcasted, or transferred to another, each of those stored recordings will be primary evidence. So if the police officers here think that it's a master negative which is the primary evidence, it is absolutely not. Explanation 6 to BSA makes it very clear that the mirror copy will also be primary evidence. Okay. Next slide. If a pen drive or storage device is to be reviewed beyond the custody of the appropriate, okay, this is a note that I made. A new pen, if the defense attorney, the prosecutor, a new investigating officer, if they require the audio-video recording, a new pen drive or a storage device should be made from the negative duplicate pen drive and be given to them. This is not the same as the mirror copy, which is submitted to the court, which will be primary evidence. Okay, third subtopic that I would like to discuss, chain of custody. How many police officers here have submitted a chain of custody form? If anyone can raise their hands, which would mean that no one has a chain of custody form to submit at a time of charge sheet, because I know seizures have been made till now. Any police officer? No one? Okay. If the operators can help me, the SOP, the file which says SOP, that can be opened for some time. Because I will just show what the chain of custody form looks like according to the SOP, which was uploaded by BPRND. Page number 61. Please type page number 61 on the side. Yeah, that one, 61. Okay. Type. Yeah, this is a chain of custody form. So from the chain of custody form, we can see the case details, we can see the device details, we can see the chain of custody documentation. Received from, received by, the reason, the sign of the receiver. Here, as I had made it clear in the previous discussions, the responder who was recording the audio video, the expert who had given his signature in part B, all of them have to be documented before this pen drive is actually submitted before the court. Okay, thank you. And just to show page number 72, 71, 71. Okay, this is part B to be filled by the expert. This person also has to be included in the chain of custody. It's important to include him in the documentation of transfer. Please, could you scroll down? Please scroll down. Okay, these are the algorithms. I'm pretty sure the investigating officers are aware by now. Please scroll down. Annexure number C, till we reach annexure number C. Okay. This is the new property search and seizure form which has been recommended by the BPRND, where I believe some police officers have started implementing this. And since this has been recommended by the BPRND, I think this is the form that we should go by now. It's more detailed. It talks about the nature of property seized. It talks in detail the date, time. It makes sure that what is to be laid down in the seizure memo, it's not skipped. So this is available online. The police officers can refer to the online PDF file that was uploaded by BPRND. SOP audio video recording is the thing that should be searched on Google. We'll come back to the slides now. Sir, I think I've crossed past 45 minutes. It's okay. You can just open the seizure file. We'll go down to, I think, page 20. Go down to page 20. Yeah. Please bear with me for some time. Page 20. Just go down fast. We'll go down. Please keep them. I'll just tell when we have to stop. Okay, I'll do it. Okay, coming back to chain of custody, we saw the form just now. Some courts, now chain of custody, it's made clear by the SOP also. Some courts can ask for video files to be submitted along with certification and chain of custody, for which a mirror file from the destination computer where recorded files have been downloaded, archived, and hashed would be supplied to the court in storage device, like pen drive, etc. I don't know if this is it has become operational now in Manipur, but the SOP states there should be an evidence specialist or data manager in the police station. He's also known as a trained Mohir. He's known as crime record munshi also in certain police stations. He is the person who will transfer this mirror image in pen drive or storage device, and I don't think this is also operational yet, to the designated desktop of the magistrate, which will receive such mirror copies. And the seizure memo, the chain of custody form also has to be provided. So it's again made very clear here. All the transfers, the chain of custody that I'm talking about, all the transfers should be depicted in the chain of custody forms with the responder and the evidence expert signing duly. Okay. BSA explanation to section 80 and 81 talks about chain of custody a little bit. Documents/electronic records are said to be in proper custody if they are in the place which and looked after by the person with whom such document is required to be kept. And there should be circumstances of this particular case which render such an origin probable. So it's from this explanation also the chain of custody stems. You have the chain of custody forms will be the document for the police officer to prove that these electronic records are being kept in such form that their origins are legitimate. And it's written here, chain of custody of electronic evidence is imperative. After it's done, a clear record of chain of custody is made, and then the seized item is handed over to forensic science lab. For us, it would be Pangai for forensic examination. Okay. I hope every police officer has paid close attention because I'll now be starting with some questions. Illustration number 1. Okay, let's try this. The brief facts of the case are that on 19 July 2024, a combined team of Commando Unit and Assam Rifles conducted random and frisking and checking along the national highway. A car and demand letter of ABC organization were seized by the official concerns, and they were handed over to ZPS police station here. In the section 63(4)C certificate, parts A and part B were filed by the same officer of the commando unit who is the owner of the mobile phone from where the audio video recording was made. Question number 1. Does this seizure suffer from any defect? Question number 2, a re-seizure memo was also submitted of only the 2 seized articles by Z police station. Does this re-seizure memo satisfy the chain of custody? It's open to the House. If any investigating officer could answer this. I've heard that some Imphal district police stations have also used chain of custody. If anyone can answer. Otherwise, this would fail to be an interactive session. So I'll go from this side. If anyone, you can choose even one question also, it's okay. In addition to the investigating officers, learned legal aid, defense counsels, prosecution, it's open to the House. Okay. So yes? Anyone? Yeah. Absolutely correct. So it's not a commando unit officer who has to give. I had listed 3 experts who can give it. It's the OC, again I'm repeating. The OC who has evidence to it, the forensic expert team which was with the police officer, and if no one is there, at least an officer of sufficient seniority who can attest that it was recorded continuously and it's authentic also. So anyone, the second part, a re-seizure memo is being submitted to court. Does it satisfy the chain of custody that a court requires? Anyone? Okay, it does not. As I mentioned, the re-seizure memo, first of all, will only contain the list of the seized items. Now the chain of custody requires signatures of the responder who recorded the audio video recording as well as the expert who signed on part B of the certificate. So the answers to both of these questions are a huge no. Illustration 2. On receipt of reliable information that there are arms and ammunition in location X and an operation being conducted, 5 9mm pistols, 3 sniper rifles, and 20 live rounds are found at location X, and then they are seized accordingly. 2 video recordings are made, one of the operation and search being conducted, and one of the seized items being seized, and the seizure memo being prepared and signed by witnesses. Only one certificate under section 63, subsection 4C is submitted before the court with the submission that both video recordings have the same hash value as they are recorded from the same phone. Can this submission stand? This is a very easy question, extremely easy. So I hope at least one investigating officer, this officer can answer this question. Maitiro on the hierarchy video ani record taweba. Koi sigi pistol phaba, 9mm pistol phaba, like sniper rifle phaba, like live round phaba gi ko. The video recording ani se amana operation tawbagi nammeba. Ani subana Seizure memo semba moi myam gi namme. Magistrate puthorpa matamda certificate amakhak puthore. Certificate sida moi bani mag hash value manei because chamanaba phone de record away na hayeba. Siyagadra. Yeah, right. Exactly, sir. Exactly. It can't be the same. Sir, could you please tell the reason why to the audience? If someone could hand over mic. Sir, oh yeah, the microphone. Exactly. No two videos can have the same hash value unless there is a hash collision. And the fact, if there is a hash collision, it means that the video recordings itself were not secure. So they can't have the same hash value. This submission won't stand. Final illustration. Okay, the details can get very confusing. There are 3 police stations here, W, Q, and T. Okay, I'm not disclosing the names of any police stations. These are real life cases, but I'm not disclosing their names. We are all here to learn. W police station conducts frisking and checking near the W police station, which is W police station, when one of the occupants of a suspicious looking vehicle gets down and runs away on seeing the police officers. The occupant who did not run away was detained, and he disclosed that the vehicle was stolen. However, ASI of W police station did not arrest the accused. Instead, he handed the accused over to QPS, relying on the fact that the accused was seen to be driving from jurisdiction of T police station to jurisdiction of Q police station. The vehicle was also not seized and was kept in the custody of W police station until an ASI of Q police station arrived at W police station on the next day and conducted the seizure. Audio-video recording is made of such seizure. Mirror copy has been provided to the court, and certificate under section 63, subsection 4, subsection C have been provided by the IO of QPS. QPS is the second PS. Is this seizure devoid of any defect? Is WPS correct in handing over the case to QPS? Is the chain of custody devoid of any defect? 3 questions here. We will start with the first question. May tayo rondos handok ko. Samna harabada sa police station ahum ne ba ko. Mingdiam ta haidok chadre ay W police station, Q police station, T police station ko pamga ko. W police station sina frisking checking conduct tawe pa. Ko police station yama naksida. Adu Q frisking checking tawa matam sa gari yama khar suspicious oiba moina phaba. Matam sida akhoi gi accused samadi occupant hai tare ne ko gari du pham amadi kumthara ma se chengre ba police uba sida. The police na di chingnare on the spot mo se phare ba ko. Matam asida occupant atopa du na haire atopa accused person gari de le hori ba du na hai gari je huran ba gari ne police uba da ki man na haidore ko. Madubu W police station moi phade ma phade accused person do. Relying on the fact mana phadri maram sina Tengopal police jurisdiction dagi Q police station ki jurisdiction bok chatto ine hai ba gari se my submission se adu ki lambi da but phabadi W police station ki jurisdiction da phado ini ko ma arrestu taude seizure do taude madubo report is submit tawe Q police station da akhoi da mi leire gari su leire Q police station oina phabiu Q police station oina seizure taubiu Siki matang se Q police station did not have any prior report. They did not ask the W police station to conduct the seizure. Moi the seizure taubiu haru pasunate. So 3 questions. Number 1, is the seizure devoid of any defect? Is the first question. Again, the last question is ina. Please kitang kaino taw na ba interactive hoy na ba amta kumse sige se. Okay, I'll just go by district. Any representative from Imphal West? Imphal West police station. We'll see which police station can answer this question. Yes. Kai da gino. Yeng se ba koi kaino answer to. Mane, exactly. Exactly. Mane, exactly. I'm not disclosing. I think the case talk paniko. I'm not disclosing which police station did this. So that question is absolutely, the answer is absolutely correct. WPS is not correct in handing over the case to QPS. The question is not there, but question amagong la eko. QPS na investigation se tawreba. Landori brahaibe question do laeba. Surprisingly, even if WPS was not correct in handing over the investigations at Laloy, because adugi provision I think it's in section 175 BNSS and previously in section 156 CRPC, jurisdiction lay in investigation tawruba se null and void oi have the adudi oi rego. So we are left with two questions still. Is the seizure devoid of any defect? Is the chain of custody devoid of any defect? I think the answer to the second question already answers these two questions. They are defective now. And with this, I conclude my session. Thank you everyone for being such patient listeners. I hope everyone has had something to take away. Thank you.
Okay. Okay, third session as well as fourth sessions ki any questions hang bidding balay gati tum hang bibayang.
I'm a bit bad with directions. So direction can.
Yeah.
Adubagi da kaigumba reason duna maram sa dargadi court na accept tobagi question ama yawgiba. Adumain togdana koi so many times we have faced this situation. I'm a forensic expert, crime scene expert. We are going along with the IOs for the crime scene investigation. Adu charpa duda akoina mob situation da nung pan bu yawe tharakana public na ko. Adu we have to security reason yenga koi chelak pa yawe ba. Aduna station the same ba. Amai to da ngasai court na accept to kibido situation yi yenga ga. Amai to certain cases da even dead body se koina yeng ba changbangam da ba because we are not trained like police personnel. Adu police personnel na changa ga dead body je puthora ga safer place da. Like encounter some years back, akogi kanoda what do you call sajik tampak thopa. Akoi mafam do yo bangam daba. Terrain then the security reason may am do not wear. Aduna koi na nearby koi Assam rifle camp da body she put examine the weba. Adu koi na whatever hand swab for the gunshot residue examination, then whatever necessary fingerprints, then nail scrapings, all those things. So koi na low haitare. Adugumba situation lakpasina okay court crimes into the satabagi aduma provision legadra ba hidi case to give value do handa ba adugumba any Supreme Court ki hearings have the koina sindu the yobangam da ba ma'am 7 years and above the compulsory or forensic examination crime scene examinations edugo certain situations arise or eba akoina yobangam da bagi hauzik su tho iba irang sina maram oiraga akoi sensitive area da akoi yokshan bangam da ba. However, police personnel singna changchalaga body puthok bagumba duga koina safer place yengba adugumba gi situation da akoi gi case gi value je handa da na ba kari provision laiga da government.
Okay, I sidadi uplo yaudre do hana sung sai case tom di yaugi ko unreasonable explanation gi kaina thobuda as well as its reasonable Supreme Court na di high grade consider tong na bado. But in addition to that, kisi case da forensic evidence na tan eyewitnesses kumba yaw ki bayaw bra. This particular case da witness credible oi ba. Case fail oi hire ba.
Case ti hana gini BNS lacting gini fail oi deba. Aduga hauzik BNS lakpa sida koi another tension am lakpa do. In such situations BNS da koi kari to da ge haibagi.
Okay. Audio video recording ta hogda bai ne ba. Whole kind of audio video recording to how drug
yes, ma'am.
Okay.
Adu should talk there to shin do so can examine to ngam dre dana. Yaushan bangam da bagi situation duna.
Okay. So ano balo ni ko? Koi gi Supreme Court na so decision di PG but ay na hining bam na sida swai ni ire ko. Hana gi high ki ba case law mas sign to ba se independent witness na so tawda yadra tawdrasu yaba natraga police witness lobasi yaba case law singse
Yes.
mandatory oina shall decision na banebko so trend oina di Supreme Court na reasonable explanation yauragadi adum lawgiba yaweko so in my personal belief if the Supreme Court believes that there is a reasonable explanation hosiki high gibado safe ma oite adugumba case but it has to be documented very clearly then the evidence might still stand but it is also required my respected Chief Judicial Magistrate ma'am
kitang eto zage ko huziki je crime scene gi mafam se photo videograph to base ngamdre situation duna haibane ba
Even changaga kone investigate tawba ngamdo.
adu gi reason do khoi sungba condition leidana reason do pb tare haibadi khoi si gumba condition leidana crime scene du da chatpa changba bawba ngamdre haibado dugo from that stage khona videograph to bangam gado ba stage to yor aga de dai to bi baduna chumgadra khalle habadi huziki hana gi reason pi gridugi adum related oira kaduini na
Okay, okay, thank you. Ma'am.
Any other questions?
Excuse me, madam. Question namta hangjage, madam. Ngasai videography ki matang se madam. Ngasai ki ahan ba hoji ki mamang da hangi ba maduna declare ore. Akoi video ki set ki da to ina thingna ba se madam. Ngasai ki sport da changye. Aduga akoi na videography to gudo se da ngasai ki hoji ki ori ba scenario se da akoi ki public na protest lakpa resistance lakpa nong tharakpa si ki timing de hoji madam na haibi gre ko. Akoi ki kitang jaga tu da briefly video ma lawraga reason to piraga di dum justified ya kanena spot amata aduga madam amada ngasai gi operation ama tawa matam da second question ngasai gi operation gi process di it may take some 1 hour also bunga machang busu laiye adu videography si akoina to gi duration ji punga madum to godra natraga kramba mongda to godigi habji kitang idea am tang pibiram thank you
so 105 105 makha di process of search se purata oina e re ko so adu ki provision do yenga di punga ma changira ani changira full to bata bane ngaha ki punga ma ani wa baduna case ngamdoini case kandoini so I don't think it's a big difficulty for the commando unit case ki matung ile so adu main laini
madam kitang supplement ngasai gi operation to wise di like it's like threat issue degi side amo degi su ngasai gi counterfeiting tor pakot pagi issue su laibe madam sigi timing se da koina videography je pura yarak to matang ju dum thengna ba
okay
adu sigi timing se da di koina kamaina sigi requirement je fulfill to ji ga ha kitang hai bio
okay so ma'am
huziki mamang da hai gi ba dumaina even for search and seizure ko sungba situation condition khara da khoi je videograph to ba ngamdre videograph to ba yadre hargadi reason to fazana reasonable ground to sina marong oi dana yadri ni haibado adu leiragadi dum ka shukai roena khanjai adu bu tawba ya ba gai dadi compulsory ne ba 105 na hari se search seizure se si loina mak video audio video electronic means sizina dana record to godo bani haibe se hairabni na in all situations aya ba gai dadi loina tawbi tare yadaba condition yarok padadi tawde yade haibado adu kitang exceptions lerakadra na khanjai
okay madam thank you on next the question yang charage asai
adu ko hai akoina sidai exceptions layena adum exception du da khoi si conditions ne yadri ni na haibadu di amuk yar oeba habdi situation du gi matung ille hai tare ko si gi situation si di lawba yar roi haibadu gi akoi adum yengbada haibadu dum khangani dana ko
okay madam knowledge to sir akoina reasonable oiba yamna solidly 100% reasonable oiba ground da dum akoi without videography dum submit kan to sir thank you
adu gi reason dum de hai bi tare
thank you madam thank you
madam koi gi police ki either commando natraga ayo da khudong cha da ba ma lei bise madam oi da chu kitang ai submission to jage koi gi learned koi gi honorable sir session sir sinju leiri akoi the dedicated tools like mobile handset natraga any camera adagi dedicated ngasai gi haibiba master record toroga thabna ba si akoi da amta phuji pawo ji pidriba BNSS generate di July dagi ni thama makai phare hojik se khudung jada ba je ngasai gi hojik ki akoi sarman thambiri duni video ji akoi dei kap kani search and seizure da phone lakchalani dedicated na tamnina mayam gi connection leibani na adu disturbance akoi da legine basa ameda adu ganda mu inau nau number hongni sumba kudong chada basi ju kitang lei adum tang koi gi medam oi da thamjani ngun
So aina hojiki hyper question se gyan ta bada phone se dedicated phone leite habani ko mainly hai se question
Charlie madam sume dedicated mobile phone adagi akoi gi ngasai gi chain of custody gi proceeding chi lorpa adagi has value gi matam chup ko na permanently akoi gi record taruga thamgadaba akoi system do adugi device do akoi do ji pau do kem to people leitri habani madam
Okay, so phone gi oina I'm not going to go into others ko state government na di ki kaino di lai re but dedicated na tragasu hojiki if the apprehension is that phone je atai purpose ke myam su sil na bani na future the accused ki counsel na question tor ka haraga so SOP da me yawe ba ko record tori matam da koi gi police officer na owner oi ba handler na but oi ra ka di ke ma kai ba laite wifi or other mobile data muthallaga record tawa record oi ra ba first instance ko adugi oina udlagati even if it's not a dedicated phone of the police station adugi audio video recording da dum valid oini for the rest I think it's more of a cost budgeting issue oina oiba maliko so duna if ma'am addition oina te ha
huziki state ki oina pi da badudi adudi state ki issue oizare ko aduga ai khoi gi sumwa khal dadi ko atopa khoi Ministry of Home Affairs ki budi SOP ma laizare akoi adu so dum illine adubu state ki wena SOP se atai state ki dum loina leina reba in Manipur ki context ta yengaga khoi gi so state ki SOP ma lai bham thokpra na di khalleba otherwise akoi je amaga manada ba ko amana follow tawbu se sunguma gi khena ba se khakha dum uiba district amaga se aduna akoi home department na adegi state na adudi moigi state ki da leire ko adui computer designated computer pi da ba khota ba habududi adudi kitang huzi already 1.5 months surabane have this gi anova criminal laws me have chatna rei se aduna adudi kitang expedite tauna tawbiraga di state na
I think ma'am aina sum khanza bada future rasigi officers sing na high apprehension lai base chain of custody form di maintain torba first of all aduga designated like tabagi anything akai ba khotpa lairaga so fazana mention tawiraba then I think the court can take
huziki oina di adugi arrangement do taw ta bane ba ko habidi huzi akoina haisine akoina mamang do so haizabado certain gray areas lai me am se proper concrete answer like tabasu yauriba adubu sina proper oini na khanbado adu tawbaduna huziki oina di dumaina tawraga oina
Madam, I can suggestion no namta thamjage judi matang da maram the investigation the police officers investigate fazna toroktra criminals sing kano da justice delivery system dagi criminals sing nanthok tan chakhi bai mahok sa ne ba aduduna madu thanawe namtari ngasi gi masal sana su law department su concern home department da sugumba darkar lebse immediately tawnana ba pursue tawbi ba yabra habi ba yabra adom doina kitang hain janinge maram di koi si ma'am si darkar leba ma'am si habi bana sumni ana khanje
yes I think sir elect have already initiated hogre na khanje ko aduga it's not only akoi adune huzi akoi stakeholders ma'am se si say new criminal law si letter and spirit tawbanga magadi it's not only for us but for the society loina maksi ki kana ga doine ba aduna akoi da gi sungam ba I think sir elect have already initiated sir elect na sigi Manipur State Legal Service Authority na ngasigi programs sinbi ra isini aduna adum tawrani na khanje
clearance samta laujage akoige akoige case register tawu matam da akoige report to complaint do oral da written da aduga electronics device da haibagi amalai gre ahambagi porchina hanadagi sananaga lairakpa oibanina akoida police ta khara adum understand tawre hojiki laiba anoba develop tawreba electronics device da mana piribase Hojiki information se SMS natraga WhatsApp natraga any electronic device tamda lak pamatamda akoina madugi portu aigi jurisdiction oigera oiroira akoina verify taurakanda verify tauba matam sidaida akoina kanode cognizable offense samdi man out taurena akoina laure aduga police na FIR ki information ama complaint ama hack phangbaga aduki duda akoigi evidence lai haragadi akoina case ama register tawam thoi like that ngasagi SMS natraga WhatsApp natraga electronic device laiba information duna cognizable offense ama lairena khanba taragadi akoina FIR ama se lobam thoi without waiting 3 days aduga akoina madugi FIR se laubam thobanina akoina ngasagi SMS tu ta cognizable made out tawrabanina akoina FIR se laure then ojeki complaint natraga SMS pirakpani pasina 3 days sidaida turn up tawraga soi tawdaba taragadi ojeki hairi ba port si akoina kari da on thoaga ngasagi soi se whether it will turn to somoto natraga karamba question da Bagi case se stand tahun gadagi. Ado madam ki ado amta koi amta punna gyan tamina bay Abraham ta advice ahu.
Okay. In electronic means ta lakpa complaint do within 3 days complainant to na sign to gado bani have any bug. In case complainant to aduna sign to drba taragadi any of his family members or relatives amana adum sign to bayai hai bako adubu sumaina su ama thengnazabane na like adu dadi aina khanbada dum victim se thogla ani na khalle akhoi rape case kumba ko adum to haidi adum gumba lakpa su dum ya doine bako adum gumba dadi within 24 hours su medical examination to da ba da ba situation ju laka doine ba aduna amalaigre in case 3 days to the sign tawraktre haragadi any person magi relatives amana sign tawba yai either sumoto yamna tasengna maki a certain tawraba si offense ma commit tawre na tasengna a certain tawbo oragadi adum sumoto lokhalasu ka shukai de aduga kaimta hadi khara complaint tok salamaga to khibo oragadi pashu tawraktragadi adum tok tho asu ka shukai de na khal case sugi matung ileba case to yamna tasengna a certain tawraba soi the sungba mas laire sungba cognizable offense ma laire prama facie mai out tawraba oragadi adum sumoto lokhola su ku kai de na khal
ado madam ma koi ge de once FIR ama lau pata ragadi FIR se either charge sheet or FR hai ba port ama la ka do banina ojeki porto whether we will wait or whenever establish the commission of cognizable offense case sudi adum FIR de adum lobam thok tabra police ki di
adu oragadi investigation do kaimta phangaroi dana habadi in case complainant na tholak tragadi kaino investigation tawrudui se du da sumoto lokhalaga phasana tawbo oragana phare aduna taba complainant la complainant na tawramaga kaimta tawdo oragadi FIR am laigre har so heng FIR in hanbadi ka shukai roi na khalli adu dadi ka
okay do itar de akoi police mayam na kari tawbo tare hojeki FIR se kari gum balau ru taragadi 3 days ki manungda hojeki SMS tharai ba kholai ba mi do laktaba taraga su magi relative laktaba taraga su cognizable offense den hai ba taragadi now the SMS turn to somoto
yes adum initiate to ba otherwise case so investigation yamna aseng na thokpa offense ama taseng na thokpa crime ama se to horoi duine ba complaint to sign to de habagi reason da
excuse me ma'am can I just add one of my colleagues just asked regarding I think in the SOP is given that there's a verification and preliminary inquiry when you have EFIR submitted to officer in charge. I'm speaking from this side, left side. I'm speaking from left side. My name is Romendro. I'm working as additional SP. So as a supervisory officers, like lots of confusions we get whenever we have any crime meetings also. I think this is one query which I wanted to also ask, but then I think the SOP is very clearly given that verification and preliminary inquiry can be done, whether the case is either 3 years or between 7 years. When any EFIR also comes, the OC can endorse to one IO, and otherwise that 3 days period. So I think the SOP, I think we can read. At the same time, I just had some queries which is not like questions but more for discussions. Firstly, I congratulate both the speakers for their very well articulated and exhaustive sessions. Thank you to both the speakers. Some of the queries that I had, like when we also guide our IOs or other OCs, is that whenever any video recording is done, say in terms of when seizure and search and seizure is done, recording is made, we have to forward that to like a district magistrate, then other SDM or judicial magistrate. So in these 3 categories of authorities, which are the records expected to be forwarded to the district magistrate or SDM or judicial magistrate first class? So that is one aspect which I want a little clarity. At the same time, whenever any video recording is forwarded within 48 hours to any of this authority, do we really need to compulsorily enclose Part A and Part B certificate by the IOs? Then,
excuse me, we'll have one question at one time.
Okay.
The mixed up the orani
Okay.
The first question to Han.
okay. The
Can
first
you please
question is
repeat?
that like we forward this record to 3, like it's mentioned in 105, it's mentioned 3 as district magistrate, SDM and judicial magistrate first class. So what kind of, what categories of offenses recording has to be forwarded to this particular, like how do we divide?
Records में होंगे. Okay.
So something like say UD
so the
cases,
first
UD case for example,
Okay.
UD case I think we can forward to district magistrate or SDM directly, right? We don't necessarily need not come to judicial magistrate first class.
Okay, so interpretation wise, I think the section itself, 105, it makes it very clear that it's either of these 3 authorities that the copies of the records can be sent, because the word or is used. It doesn't say N. It's not all of these 3 authorities that the copies of the records shall be forwarded. Second question with regard to section 63 certificate, it is the certificate which will authenticate the particular electronic device. So be it part A, part B, it will have to be submitted. If it can't be submitted to the first duty magistrate, at least by the time it's submitted along with chain of custody, by the time the charge sheet is filed, it should be there. So both of them will have to be filled.
So in that 105, do we read as or? Because the thing is that in district magistrate, like say suppose when we do an FIR and then maybe produce an accused along with the seized item, we don't generally take to district magistrate, right? So like are there any categories of offenses where we particularly take to district magistrate? I mean that's a little clarity that I want, because that's something like
Okay, I don't know what's the new provision under BNS, but the chapter with regards to good behavior, that prevention, which the district magistrates are related with. Ma'am, if you can add those that particular chapter. I think it starts from section 106. There's unnatural death also, but 106, 107, 108 CRPC, I'm unaware of the correlating cases. So in those CRPC provisions also, the district magistrate, the subdivisional magistrate, they would be the authorities concerned. But I would say that since the charge sheet will finally be submitted to the court, the best authority would be judicial magistrate first class. Except for those cases where district magistrates or subdivisional magistrate, they're explicitly mentioned in other parts of the code.
Okay, and one last query. Like I think even Ministry of Home Affairs in CRB, they are developing this app called eSaksha, which is basically trying to record all this videography for various categories. So once this is once this goes live, then I think right now all the IOs have actually installed this app on their particular phones. I think once this goes live, then we necessarily may not be submitting again pen drive or CD or the memory card to the judicial magistrate, because will that be connected to your and entire judiciary court as well? How is the?
I think we'll know when the app, the platform gets finalized. It's still in process, as far as I'm aware.
Rajasthan has already
Okay, so sir is more.
The thing is that whenever you make the audio video Seizure video, you directly upload with this one. So what happens is that this video cannot be downloaded. So you can directly share the link with the court. Also now audio video, this Seizure video, when it makes this one, it will make a part of 193, that is a charge sheet. That means to say that you have to give the video clipping of the Seizure video, section Seizure video to the accused also. Now what happens, you share the link with the accused as well as the court. The beauty of this app, eSaksha app, is that it is not downloadable. So that's why the hash value or the integrity of the video will be intact and it will be long lasting. This is the one thing. As far as that one question I observed, another one is the preliminary, that is the FIR that has been there. What is the modus operandi? Now, for example, I get an electronic communication complaint. It is not new actually. The only wording is new. That is in 173, that is by electronic means or irrespective of the area. Now, for example, a Manipuri guy gone to Delhi and he files an FIR through Delhi police website and the EFIR. That is there, the EFIR. The law says within 3 days he has to come to the police station and this one. But that is not compulsion for him to this one. Why the signed document of the FIR is required is because in the court, in trial, somebody has to prove that it is the FIR and it is filed by me. Second thing is that why they insist on the written, that is the signature, means tomorrow anonymous complaints may come. Somebody non-existing person may complain against him stating that this is a complaint. To prevent these things, the written signature of this one and 3 days has been given. Now I receive an EFIR. As per the Lalitakumari judgment, when the cognizable offense has been made out, nothing stops you from starting the investigation. Because a rape offense has been heard to the police station, I will not wait for registration of the FIR. Suddenly I will embark on investigation. So you start the investigation, that's why the nature and gravity of the offense has been involved. Now see the EFIR, and if there is a contact number or the contact address, call the person complainant, make sure that there is a human being behind that complaint has been made. If he comes and signs it, that's fine. Or if he does not come, for example, he has gone to ESA. Person is there, he has gone to ESA. He cannot come. Now what happens? You depute an officer to make verification of the contents of the FIR, and whatever the verification he produces to the police station will become part of FIR. Take that as a complaint and register the FIR. Now what happens after 3 days he was out of station and he came. He says that, sir, earlier I have put up a complaint, now I want to sign it. But already FIR has been signed. Treat his statement, subsequent statement, as a witness statement. Because already the complaint has been registered and there is a complainant suo motu is there. Later, subsequently, after 3 days he come, treat that as this one. Now what happens to the earlier, that one, which is the unsigned document, that acts as an information. The information need not to be signed. So these are the things that are there in the SOP also. FIR e-complaint has been received, take it as an information. If it is signed, it's okay, digitally signed, it's okay. Or if you can able to summon him and get the signature, fine. Or if it does not come and there is an imminent requirement of registering FIR, do the verification, just got the verification report. Based on the verification report, you can start the FIR copy. This is what this one. Yeah. There was another question, I think, that related to, I could not get it. Video. eSaksha app, what happens is that, now the problem with the eSaksha app is that, now we cannot download or we cannot fully upload the whole entire video. For example, 1 hour. It will only uploads only 4 minutes, 4 minutes, 4 minutes. So now it is very difficult to chain all the 4 minutes videos in the eSaksha app. That's why even the Telangana police, what they have made, they made standard operating procedure how to conduct a Seizure video. First 1 minute, they made that introduction of the parties. For example, I took a warrant, I go into the search and place, then I introduce myself that I have come to your place, this is the FIR, this is the search warrant, and these are the 2 independent witnesses. And also it includes voluntarily body search. Before I embark on a search to somebody, I had to offer my body search first. So this contains first 1 or 2 minute video. Then second thing, you, whatever the important things that has been searched and all those things with the witnesses, you make that one. But 105 says the two important things. The compulsory signing by the witnesses, independent witnesses, should be there in the place where the search has been made. As we mentioned in some of the case laws, police have the habit of making the seizure of all the documents in the search place, take to the police station, whether relevant or not relevant, then they make the seizure memo, then they call the independent witness, then they call the owner of the documents, then they prepare. This is usually, and there is no timeline. But now, they have to prepare the search and seizure memo in the place where search memo, and the video should compulsorily include the signing of the witnesses, and also the preparation of the seizure memo, and also 48 hours. Now, why 48 hours? Now, in one place if I am searching 48 hours, excluding the time taken journey is not an issue. I can go to the concerned judicial magistrate and submit it. But what happens if there is a multiple searches, like in 165B, now 185B? For example, in Manipur, I made 10 districts, 10 searches. Then the last search made, and when they arrived at the police station, then the 48 hours start. So the last search made, then the 48 hours actually, the time lag starts. This is the what we can see from the search and seizure video also. Yes.
Thank you so much, sir.
Thank you so much, Sarah Sekha. Sarah Sekha will be the resource person in tomorrow's sessions. I think huziki answer do na kya rabra na khanje.
Yeah, I believe in sticking with the time. So you have just seen some of the preludes of tomorrow's session, the last session I should say. So,
Yes.
I think Sarah is there to answer your queries. Just you have to be present. So I think we are running out of time, out of the schedule. So I think we have to wind up. And then we'll please come on time tomorrow also. Please, Praveen, you may take over, please.
Thank you. Thank you.
Thank you, Ms. Sarungbam Mangaleibi, Ms. Neera, Sinam, and Madam Tarunakumari Devi for such an enlightening deliberation on the topics of pre-arrest, pre-trial procedures under the BNSS, including arrest, seizure, and preliminary inquiry. I now request all the participants to kindly join us for tea. With this, we wind up the day one of our orientation program. I hope to see everyone tomorrow at 9:30 a.m. for a cup of tea and commencement with day two. Thank you. One more announcement, please. Okay, not the Like says, so the no Pukiba Kaya or Hainare, do Kano Labata, the Hayamta, Pibira, Prapondia, Pram, the Hibiro. Thank you. Like Tom the Hayang Harry. Not other, is I say table them like the Tambira Moko, the Lotions again. Adam Tambira. Thank you, ma'am.